Section 18. Powers of companies. 1. Subject to this Act and to any other enactment, a company shall have a. Full capacity to carry on or undertake any business or activity, do any act, or enter into any transaction, and b. Full rights, powers, and privileges for the purposes of paragraph a. 2. Without limiting subsection 1, and despite the provisions of any other enactment, a company shall be capable of giving and entering into and being bound by and claiming all rights under a deed or mortgage or other instrument. 3. The registered constitution of a company may contain a provision regarding the capacity, rights, powers, or privileges of the company if the provision restricts the capacity of the company or those rights, powers and privileges. Section 19. Limits of authority of company. 1. Where the registered constitution of a company sets out the nature of business or objects of the company, there is deemed to be a restriction in the registered constitution on the business or activities in which the company may engage, unless the registered constitution expressly provides otherwise. 2. Where the registered constitution of a company provides for any restriction on the business or activities in which the company may engage. A. The capacity and powers of the company shall not be affected by that restriction, and b. An act of the company, a contract or other obligation entered into by the company and a transfer of property to or by the company shall not be invalid by reason only of the fact that it was done in contravention of that restriction. 3. Subsection 1 shall not affect the application of the provisions of subsection 5 and sections 200, 219 and 275. 4. Despite subsection 1, an act of a company and a conveyance or transfer of property to, or by, a company is not invalid by reason of the fact that the act, conveyance, or transfer was not done or made for the furtherance of any of the authorized businesses or that the company was otherwise exceeding its objects or powers. 5. On the application of a member of the company, or b. the holder of a debenture secured by a floating charge over all or any of the property of the company or by the trustee for the holders of those debentures, the court may prohibit, by injunction, the doing of an act or the conveyance or transfer of a property in breach of subsection 1. 6. Where the transactions sought to be prohibited in proceedings under subsection 5 are being, or are to be, performed or made in accordance with a contract to which the company is a party, the court may a. If the court considers it equitable and if all the parties to the contract are parties to the proceedings, set aside and prohibit the performance of the contract, and b. Allow for the payment of compensation to the company or to the other parties to the contract for the loss or damage sustained by the company or the other parties by reason of the setting aside or prohibition of the performance of the contract, but not compensation for loss of anticipated profits to be derived from the performance of the contract. 7. The capacity of the company to do an act shall not be affected by the fact that the act is not, or would not be, in the best interest of a company. Section 20. Attention of objects or business. 1. Where applicable, a company may change the business for which the company was incorporated to carry on, or in the case of a company not formed for the purpose of carrying on a business, the objects of the company by special resolution. 2. Within 28 days of the passing of the special resolution under subsection 1, notice of the resolution shall be given in the prescribed form to the holders of the debenture secured by a floating charge over any of the property of the company and to the trustees for the debenture holders. 3. Where a company defaults in giving a notice as required by this section, the company and every officer of that company that is in default is liable to pay to the registrar an administrative penalty of 50 penalty units. Section 21. Names of companies. 1. The last words of the name of a private company limited by shares shall be Limited Company, or the abbreviation Ltd. b. Public company limited by shares shall be Public Limited Company, or the abbreviation PLC. c. Company limited by guarantee shall be Limited by Guarantee, or the abbreviation LBG. And d. Private company unlimited by shares shall be Private Unlimited Company, or the abbreviation PIUC. E. Public company unlimited by shares shall be Public Unlimited Company, or the abbreviation PUC. 2. A company shall not be registered by a name which, in the opinion of the registrar, is misleading or undesirable. 3. A company shall not be registered with the name of a company that has been dissolved within the preceding 5 years of the intended registration. 4. A company may in writing change its name by special resolution and with the written approval of the registrar. 5. Where, through inadvertence or otherwise, a company on first registration or on registration by a new name is registered by a name which, in the opinion of the registrar, is misleading or undesirable, the company shall change the name of the company with the approval of the registrar. 6. Where the registrar so directs within 6 months of the company being registered by that name, the company shall change the name within a period of 6 weeks from the date of the direction. 7. Where the registrar is of the opinion that by reason of a change in the objects of, or the nature of the business carried on by a company, the name under which the company is registered is misleading or undesirable, the registrar may direct the company to change the name and the company shall change that name within 6 weeks of the direction, unless within that time the company has lodged an appeal to the court against the direction. 8. The court shall cancel or confirm the direction, and if the direction is confirmed, the company shall change the name within 6 weeks of the confirmation. 9. Where a company defaults in complying with a direction under subsection 6, 7, or 8, the registrar shall change the name of the company in the register. 10. Where a company defaults in complying with a direction under subsection 5, 6, 7, or 8, the company and any of the directors of the company that are cognizant of the default are liable to pay to the registrar an administrative penalty of 25 penalty units and a further penalty of 50 penalty units for each day that the default continues. 11. Where a company changes the name of the company under this section, the registrar shall record the new name in place of the former name, and shall issue a certificate of incorporation that indicates the change of name. 12. Pursuant to subsection 11, the registrar shall advertise the change in the company's bulletin, the website of the Office of the Registrar of Companies, and in one daily newspaper published in the Republic and circulating in the district in which the registered office of the company is situated. 13. A certificate or an advertisement in the company's bulletin under this section is conclusive evidence of the change to which the change of name relates. 14. A change of name by a company shall not affect the rights or obligations of the company or render defective legal proceedings by or against the company, and legal proceedings that might have been continued or commenced against the company under the former name may be continued or commenced against the company under the new name. 15. A company limited by shares existing at the commencement of this Act has 6 months within which to comply with paragraphs B and C of subsection 1. Section 22. Reservation of name. 1. An application for reservation of the name of a company may be sent or delivered to the registrar, and shall be in a form approved by the registrar. 2. The registrar may, after receipt of the application and on payment of the prescribed fee, reserve a name pending registration of a company or a change of name by a company. 3. A reservation under subsection 2 shall not exceed 2 months and may be renewed for a further period of 2 months. 4. A company shall not be registered under a reserved name or under any other name which in the opinion of the registrar is similar to the reserved name.